Mr. Lewison.
So I rise in support of the bill. This is a swift legislative response to the Court of Appeal's proposal in the case of Dabler Fortune Inc. versus Duncan Cameron Lindsay, as the Minister has pointed out, to carve out liens on sub-freights from the registration requirement under Section 1311 of the Companies Act. As the law currently stands, given the Court of Appeal and High Court decisions that characterize a lien on sub-freights as a floating charge and a charge on a company's book debts, a ship owner must register its lien as a charge under the Companies Act, failing which this lien will not be valid against other creditors. However, this requirement is viewed by the industry as onerous and commercially inconvenient for charter parties that are usually of relatively short durations. This reform will resolve the dilemma ship owners face between expediency and protection of their rights to exercise the lien. The proposed statutory carve-out differs from the Hong Kong approach, which the Minister had also mentioned, which provides under Section 3344 of its Companies Ordinance that a lien on sub-freights is not a charge on book debts of the company or a floating charge for the purposes of registration. Given that the outcome on the registration requirement is in effect the same, can the Minister clarify if there are any other practical implications that are intended in affirming the Singapore Court's characterization of a lien on sub-freight as a charge on book debts of the company or a floating charge? Given the lack of clarity on the characterization and registration requirements of liens on sub-freights prior to the Court's decisions, and this amendment, shipping companies and creditors would understandably have acted according to what is most commercially expedient. In practice, registration of liens on sub-freight is not commonplace, especially for short charters. This new Section 1313AC provides for a period of transition by clarifying that the consequences of non-registration should only apply prior to the amendments commencing where there is a liquidator or creditor. Until the new amendments take effect, under Section 1321 of the Companies Act, the liener or company and every officer of the company is guilty of an offence and liable to a fine for not registering such a lien. Can the Minister clarify whether these penal consequences will be applied against shipping companies and their officers? Clarification notwithstanding, I stand in support of this bill, which provides much needed clarity on this area of law and is in line with commercial practice.